Every time you swipe a credit card, sign a mortgage, or take out a personal loan, you are relying on a hidden legal safety net. You probably assume that if a medical emergency or job loss wipes out your finances, the government has always provided a standardized way to wipe the slate clean. But the universal, standardized federal consumer bankruptcy discharge we know today was not actually introduced until 1978. Before that year, walking away from personal consumer debt was a chaotic, punishing, and often impossible maze. This raises a massive historical question. Who decided that an ordinary citizen could legally break a financial contract and walk away from their debts without facing prison or permanent ruin? The answer is not just a story of financial mercy, but a brutal battle over economic power, risk, and who actually controls the American working class. To understand how this modern safety valve was engineered, we have to examine the brutal architecture of early American credit. In the early 19th century, the concept of a consumer wiping away debt simply did not exist. If a farmer or laborer borrowed money and failed to pay, the consequences were entirely punitive and localized. There was no federal system to process personal financial failure. The local magistrate docket book from this era recorded these defaults not as civil restructurings, but as quasi-criminal offenses. A creditor would present a signed promissory note to the local sheriff, who was authorized to seize the physical property of the debtor immediately. If the seized property fell short of the balance, the physical body of the debtor was the next available asset. The framers of the Constitution had actually included a clause allowing Congress to establish uniform laws on the subject of bankruptcies. However, early lawmakers viewed bankruptcy as a specialized commercial tool meant strictly for merchants and traders, not for ordinary consumers. Debt among the working class was viewed as a deep moral failure rather than an economic inevitability. Congress passed the first Federal Bankruptcy Act in the year 1800, but it was a temporary measure driven by a specific financial panic. It allowed aggressive creditors to force merchants into bankruptcy to liquidate their assets, but it offered absolutely no voluntary relief for a regular citizen drowning in debt. The public hated this system so much that Congress repealed it just 3 years later. Debtor's prison remained the primary American mechanism for handling unpaid personal loans well into the 1830s. Men and women were locked in county jails, entirely responsible for paying for their own food and blankets while incarcerated. They sat in freezing cells until family members could somehow raise the funds to satisfy the angry creditor. The pattern repeated exactly in 1841, following another massive economic depression. Congress temporarily passed a new act that briefly introduced the radical idea of voluntary bankruptcy, allowing individuals to ask a court for relief. But creditors revolted against the idea of everyday debtors initiating their own escape, and this law was repealed in just over a year. A third attempt arrived in 1867, designed to handle the massive economic wreckage following the American Civil War. This act lasted 11 years, but was plagued by exorbitant administrative fees and rampant corruption among court-appointed trustees. For the average wage earner, paying the steep legal fees just to file for bankruptcy was mathematically impossible. The foundation of modern federal involvement finally arrived with the Bankruptcy Act of 1898. This legislation created a permanent federal framework, ending the exhausting cycle of temporary emergency laws. Yet it was still fundamentally designed for corporate liquidations and business failures, leaving everyday wage earners in a precarious legal gray area. The original 1898 federal court ledgers show a process entirely unsuited for consumer debt. An ordinary worker filing under this act had to surrender virtually all their physical possessions to a court liquidator to be auctioned off to the highest bidder. There were no standardized federal exemptions to protect a family home, basic tools, or a vehicle from being completely liquidated. By the 1920s, the American economic landscape underwent a radical transformation that made the 1898 bankruptcy framework entirely obsolete. The invention of the installment plan allowed ordinary citizens to purchase automobiles, radios, and washing machines on credit. For the first time in history, the average wage earner was carrying significant, formalized consumer debt. When the stock market collapsed in 1929, it triggered the Great Depression and exposed the catastrophic flaw in this new credit economy. Millions of workers lost their jobs overnight, rendering them entirely unable to make their monthly installment payments. The existing bankruptcy system offered these drowning consumers no realistic escape hatch. Instead of bankruptcy, creditors weaponized a devastating legal tool against the working class. The standard municipal court wage garnishment order allowed a creditor to legally intercept a worker's paycheck before it even reached their hands. Employers were legally compelled to divert up to half of a desperate worker's wages directly to the debt holder. This merciless garnishment system created an endless cycle of poverty and job loss. Many employers simply fired workers who received garnishment orders rather than deal with the administrative nightmare of splitting their paychecks. Facing starvation, millions of Americans were trapped in a financial purgatory with no federal mechanism to discharge their overwhelming debts. Congress was finally forced to intervene in 1938 by passing the Chandler Act. This sweeping legislation completely overhauled the bankruptcy system and introduced a revolutionary new concept specifically designed for the working class. It was known as Chapter 13, or the Wage Earner Plan. However, this was not the immediate, clean slate discharge that modern consumers rely on today. The Chapter 13 court petition required the debtor to submit a strict, multi-year repayment proposal to a federal judge. Instead of wiping the debt away, the government essentially took control of the citizens' finances to ensure creditors were eventually paid. The federal bankruptcy trustee's ledger became the ultimate authority over a family's survival. The trustee collected the workers' wages directly, distributed a meager living allowance back to the family, and sent the rest to the creditors. It was a state-enforced budgeting system, not a true financial pardon. This rigid repayment system barely held the economy together until the end of World War II. In the 1950s and 1960s, the American financial sector unleashed an entirely new weapon onto the middle class. The introduction of the universal revolving credit card fundamentally changed the nature of personal debt. Unlike a mortgage or a car loan, credit card debt was entirely unsecured. If a consumer defaulted, there was no physical property for the bank to repossess and sell to recoup their losses. Banks rapidly issued millions of these high-interest plastic cards, creating a colossal, unprecedented pool of invisible consumer debt. By the late 1960s, the Chapter 13 wage earner plans were collapsing under the weight of this new, unsecured debt. Workers who suffered a medical emergency or a factory closure found that even a court-mandated repayment plan was mathematically impossible. They were drowning in massive interest charges, and the old system offered no mechanism to simply wipe out unsecured credit card balances. The rising tide of permanent financial ruin forced lawmakers to acknowledge that the old, corporate-focused bankruptcy code was destroying the American middle class. In 1970, Congress established the Commission on the Bankruptcy Laws of the United States. This specialized commission was tasked with designing a completely new federal architecture for handling consumer financial debt. For 8 years, this commission engaged in a brutal bureaucratic war with the banking industry. Creditors fought fiercely to maintain the old system of mandatory repayment plans and wage garnishments. They argued that giving consumers a legal right to walk away from unsecured debt would destroy the American credit system entirely. The Commission's official hearing transcripts reveal a deep fear among lawmakers regarding the sheer power of modern banks. Politicians realized that without a standardized escape hatch, a massive underclass of permanently indebted citizens would eventually drag down the entire national economy. The debate shifted from moralizing about personal failure to recognizing that mass debt forgiveness was actually an economic necessity. Consumer advocates argued that the risk of default should be borne by the sophisticated banks issuing the credit, not solely by the vulnerable citizen. If a bank freely mailed out high-interest credit cards, they had to accept the reality that some borrowers would inevitably fail. The stage was finally set for the creation of a modern, standardized legal pardon. The climax of this decades-long struggle arrived with the passage of the Bankruptcy Reform Act of 1978. This monumental legislation finally established the modern, standardized federal consumer bankruptcy discharge we recognize today. It completely rewrote the legal relationship between the American citizen and the banking industry. The centerpiece of this new system was the standardized Chapter 7 discharge petition. This document allowed an ordinary consumer to legally wipe out entirely massive amounts of unsecured debt, including credit cards and medical bills, without a mandatory multi-year repayment plan. It was the introduction of a universal, federally protected fresh start. Furthermore, the 1978 Code established robust federal exemption schedules. A federal bankruptcy judge's exemption ruling explicitly protected a debtor's primary residence, their vehicle, and their necessary household goods from liquidation. A family could now legally break their financial contracts, discharge their unsecured debts, and still keep a roof over their heads. The banking industry lost their absolute power to trap working-class citizens in permanent wage garnishment. The automatic stay provision immediately halted all creditor collection efforts the moment the bankruptcy petition was filed. The federal government had finally decided that the economic survival of the individual citizen superseded the absolute sanctity of a private debt contract. However, the passage of this act sparked a ferocious counteroffensive from the financial sector that persists to this day. Throughout the 1980s and 1990s, credit card companies aggressively lobbied Congress to roll back these consumer protections. They argued that the new discharge system was too lenient and encouraged ordinary people to recklessly abuse credit. This relentless lobbying eventually led to the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. This law introduced a brutal means test calculation, requiring debtors to prove their income was below a certain threshold to qualify for a clean discharge. It made filing for bankruptcy significantly more expensive, complicated, and punitive for the modern consumer. The tension between financial mercy and corporate profit remains a defining feature of the modern American economy. We still debate whether massive student loan debt or catastrophic medical bills should be eligible for this federal pardon. The system created in 1978 was a monumental victory for the working class, but the architecture of that relief is constantly under siege by the institutions that hold our debt. The history of consumer bankruptcy is not just a tale of legal codes. It is the story of how a society decides to manage financial failure. Do you believe that individuals should always be held strictly liable for every debt they sign, regardless of medical or economic disasters? Or is a standardized legal escape hatch essential for a functioning, humane economy? The systems that control your money, your debts, and your future were built by powerful people with specific agendas, and their origins are often hidden in plain sight. If you want to understand the true architecture of the modern world and the historical battles that shape the rules you live under, subscribe to the channel.